All right, welcome to the explainer. So let's say a lawsuit lands in court, but it's all about some super technical, complex science. I mean, way over a judge's head. What happens then? Well, it turns out there's a really interesting century-old legal tool designed for exactly that situation.
I mean, really think about that for a second. You've got a huge case, maybe about a new drug patent or some complicated environmental rule. The judge, an absolute expert in the law, for sure, but in biochemistry or climate science, probably not. So how are they supposed to make a fair, informed decision? That's the big, thorny question we're going to dig into.
And this isn't just some hypothetical question. It's a genuine dilemma that courts have been wrestling with for more than 100 years, especially as our world gets more and more complicated.
Yeah, think about it. Back in the day, it was stuff like railroad shipping rates. Today, it could be anything from telecom regulations to the latest biotech. Courts are constantly getting these cases that really belong to specialized government agencies. So they're kind of stuck between a rock and a hard place, right? They have to resolve the case, but they don't have the expertise. What do you do?
Well, the answer is this really clever legal doctrine called primary jurisdiction. And honestly, the best way to think about it is like the court's ability to say, you know what, this is above my pay grade, let's call in a specialist.
Now, to be clear, this isn't about the court just throwing up its hands and giving up. Not at all. It's a tool for coordination. So when a case pops up with a super technical issue, something the FDA or the EPA is literally built to handle, the court can just hit the pause button on the lawsuit and ask that agency to take a look first.
And this whole thing really boils down to two main goals. First, expertise. Pretty straightforward, right? Let the experts be experts. But the second one, uniformity, is absolutely crucial. Just imagine the chaos if a court in California made one ruling on a national regulation and a court in Florida made a completely different one. It would be a mess. So by sending it to one national agency, you make sure the rules are the same for everybody, everywhere.
And the Supreme Court itself basically said, yeah, this is just common sense. This quote really gets to the heart of it. The court is saying, look, if there's an issue that judges just don't deal with every day, and Congress literally created a whole agency to be the expert on that exact thing, well, it would be pretty silly to just ignore them, right? You've got to use the tools you've been given.
So where did this idea even come from? Well, it didn't just pop up overnight. It was actually born during a really wild time of change in America, the dawn of industrial regulation.
You can kind of see how it all unfolded. It starts back in the late 1800s with the rise of the railroads and the creation of the first big federal agency, the Interstate Commerce Commission, or ICC, to keep them in check. Then, bam, 1907, you get a landmark Supreme Court case that says the ICC has to be the one to decide on shipping rates first. That's the birth of the doctrine right there. And then it gets refined over the years until a big case in 1956 really locks in the modern version we're talking about.
Okay, so that's the what and the why. But what about the how? Like, what does this actually look like when it happens in a real courtroom?
The whole process is actually super logical. My favorite analogy is to think of the court as your family doctor. You go in with chest pains. Does your doctor just start guessing? No way. They refer you to a specialist, a cardiologist, right? The court does the exact same thing. It sees a problem that needs an expert, it hits pause on the case, sends the question over to the right agency, waits for their opinion, and then, and only then, resumes the case, but now with that expert input. It just makes sense.
And legal scholars totally back this up. They say the whole point is, 1, to make smarter legal decisions by using expertise, and 2, to keep things uniform across the country. It's a beautiful, elegant solution on paper. Keyword there, was. Because this is where the story takes a big, unexpected turn. That elegant solution we just talked about, well, it crashed head-on into the messy, complicated reality of our modern world. Get this, today, that whole doctrine is almost never used. Seriously. Even with its clear purpose and the Supreme Court's blessing, judges almost never pull this tool out of their toolbox anymore. The perfect solution became a casualty of real life.
So, what on earth happened? Well, the short answer is just one word: time. In theory, sending an issue to an agency sounds great. In reality, it's a logistical nightmare. It can add years to a lawsuit. Think about it. These agencies are already completely swamped. A request from a court, it goes into a very long line. And all the while, the courts are under pressure to get cases resolved. The doctrine, instead of being a solution, became a massive bottleneck. But here's the cool thing about the law. It evolves. It's not static. When one tool gets old and rusty, the system finds a new, better way to do the job. And that is precisely what happened here.
And this chart just lays it out perfectly.
The old way, primary jurisdiction, was this formal, super slow, and really demanding process for the agencies. The new way? It's informal, it's fast, and it's way less of a headache for everyone involved. It's all about getting an amicus brief.
So this is the modern workaround. Instead of this whole formal referral process, courts now just ask. They invite the expert agency to file what's called an amicus brief, which literally means friend of the court brief. The agency writes up its expert opinion, sends it over, and the court gets the information it needs without hitting pause for 3 years. It's the same result, expert input, but it's 1,000,000 times faster and more efficient.
So really, the story of primary jurisdiction is this incredible case study in legal evolution. You have this idea that was born for the age of railroads, and you see it adapting to survive in the age of the internet. And it makes you wonder, right? What other big, old-school legal rules are being quietly updated right now to keep up with the crazy pace of our modern world?
And just a quick reminder, this is for entertainment and educational purposes only. This is not legal advice.